All right, lock it up. I have something to say. You know what the great thing about being back in the veteran community is everybody pays attention to you when you say something like that. I appreciate it. I don't really need anything. I just wanted to share that with you to see. I see because everybody's watching. And I'll share this with everybody. I was like, hey, look, you want to know the greatest thing about veteran service members? Man, they pay attention when somebody's talking. We're not there like really paying attention, but we do. So thank you. Thank you for your service. Thank you for what you're doing currently. And God bless each and every one of you. I always like to throw, I have a tendency of, I know there's Army Rangers in here. Any Army Rangers in here? Is there one? All right. So I'm going to add this. I like to add this every time we have a lot going on today. It may just be me today. I hope not, but we have to wait for Mr. McGarvey to show up and the other members, but it's been a busy week in Washington, D.C. Anyway, I go back to my Army Rangers. There's like this love-hate relationship I have with Army Rangers. Like I really hate them. And I'm a Navy guy. I don't know if you guys know. There it is. What's up? Normally, you're supposed to say I don't like Marines because I know there's Marines in here that could see you. You guys sit differently than everybody else, and you young ladies. Yep. But working with the Army Rangers, like I don't like the way you look. I don't like the way you walk. I don't like the way you talk. It's a thing. But Army Rangers saved my brother's life in Afghanistan, so I'm internally indebted to Army Rangers. It's like this thing in me that eats me alive every day. When I see one, I'm like, I hate you, but I love you and thank you. Anyway. All right, there we go. So welcome to our committee. Again, it's 10 o'clock. I'm very punctual, and I normally kick things off quickly, but our members are scattered through D.C. You guys are tracking everything that's happening throughout the week and then into this week. I just actually left a traumatic brain injury conference talking to some subject matter experts in the traumatic brain injury space, which is very near and dear to all of us. So I'm gonna close the mic down. You guys continue smartly, and then when Mr. McGarvey and another member show up, we'll start the hearing. Okay? And I apologize. It's not my fault. I was here on time. You guys saw that, right? All right. Cool. All right. Thank you. You ready, buddy? Okay. Subcommittee on Disability Assistance and Memorial Affairs will come to order. Before we start, I've just been told that one of our colleagues, Mr. Sylvester Turner, he's actually from Texas, was the former mayor of Houston, passed away. I'm not sure if it was last night or this morning, but may we please have a moment of silence for our fallen colleague. Thank you. Our thoughts and prayers are extended to the Turner family. Not how I want to start my day off, but all right. Thank you all for joining us today. We're here to discuss 3 bills that would each reinstate criminal penalties for anyone who takes advantage of veterans who are filing claims for VA disability compensation. Last week, I personally heard from veterans advocates testifying on the bad actors for charging $30,000 or more to assist veterans for filing their claims. I think we can all agree that veterans should never, ever have to pay $30,000 or more for assistance filing a VA disability compensation claim. I have also heard from veterans that they want the freedom to choose who helps them file their initial claims. Under the current law, companies are not allowed to charge a fee for assisting veterans with claims at the start of the claims process, limiting their options. At today's hearing, we will be discussing H.R. 1656, the PLUS Act, which would reinstate fines and jail time for companies that violate laws regarding representation of veterans pursuing VA benefit claims. The PLUS Act would also allow VA-accredited agents and attorneys to charge a limited fee to assist veterans with filing their initial claims for VA disability compensation. Second, H.R. 1732, the GUARD Act, would reinstate fines for violations of the law regarding the representation of veterans before VA. Third, the discussion draft on today's agenda would reinstate fines and jail time for violating the laws governing the representation of veterans before VA. The discussion draft would also allow VA-accredited agents and attorneys to charge a limited fee while assisting veterans with filings on their initial VA benefits claims while prohibiting fees for certain types of initial claims. I believe that regardless of the bill anyone supports, we must ensure that the veterans is at the center of the changes we make. I look forward to a productive discussion today about the 3 bills on our agenda. We have not currently received VA's views on these bills. Secretary Collins has only recently began leading the VA, the second largest federal agency in the nation. In my opinion, he is still and currently getting his sea legs underneath him. Because the VA did not have its views cleared in time for our hearing, it was not in the best interest of everyone's time to have them come and testify. Because we do need VA's views, we will keep the record open for them. It is not uncommon for us to receive VA's views after hearings, and I think the witnesses who have joined us today will understand. I now yield to the ranking member for his opening remarks.
Thank you, Mr. Chairman. I also echo your initial sentiments for our colleague Sylvester Turner from Texas, for his family. Not only was he a distinguished member of this body, also a very well-respected mayor across the country for his work there. A loss. Mr. Chairman, I appreciate you all having this hearing. Appreciate everybody for being here today. I'm here for one reason today. It's not to protect turf in any turf wars. It's not to defend the status quo. It's not to whine and complain about things that don't matter for veterans' daily lives. I'm here for one reason: to ensure that our veterans can access their earned benefits without delay and without being ripped off. Now, I want to get this right, which is why I think it's important to hear from everyone. However, I also want to point out that we have one critical absence today. Mr. Chairman, you mentioned the VA is not here, and I understand that there's a new secretary. We did, however, receive written testimony from them, and I don't think it actually said all that much. It said they're reviewing their bills. They couldn't give their views at this time. And again, I know they're new, but it's hard to hold a legislative hearing without knowing where the VA stands on these bills. And I think that's particularly important right now because they have been so supportive of the GUARD Act in the past. And I hope their absence in reviewing this bill is not a signal that they are doing a 180. Because if the Trump administration is now going to support these companies who've been fleecing veterans out of hundreds of millions of taxpayer dollars, money that is meant to help our veterans, then I do hope they will show up in front of this committee and tell us why. Now let's get to the topic at hand. My goal, and I think one that is shared by all of my colleagues here, is to alleviate the circumstances that lead any veteran to feel as though they have to pay to access the benefits they've earned. We should strive for a process that doesn't necessitate paid assistance, that is simple to navigate, that is quick to deliver an outcome, and that results in a pro-veteran decision. I think anything short of that is window dressing. But don't take that to mean, Mr. Chairman, that I'm not interested in cracking down on those who are violating the law. Quite the opposite, in fact. It's clear that back in 2006, Congress made a mistake when it repealed penalties for assisting with disability claims without accreditation. I don't think anyone could have anticipated a cottage claims industry so brazenly flouting the law. That cottage industry, it's not so quaint anymore. In fact, we're talking about numerous large companies that are siphoning off hundreds of millions of dollars a year in veterans benefits. Companies that are attracting venture capital funding and working on Wall Street offerings, all to make a quick dollar on what has for decades been a free service. I understand. We live in a country where everyone's trying to make a living, and if people can find a way to make a buck, they will, even if that means profiting from veterans' disabilities. Unfortunately, these companies have deep pockets, which they use to buy influence. So we've been at a stalemate here for years between those of us who want to crack down on this illegal behavior and those who want to bless it. I think we're going to hear a lot about veteran choice and systemic capacity at today's hearings. I want to point out that there is a great deal of choice already with thousands of accredited representatives able to help, not to mention VA's longstanding duty to assist. And VSO capacity is robust and growing, especially with the new non-traditional VSOs coming on boards, such as tribes and labor unions. So this isn't about taking away veterans' choices for me. There's a lot of choices out there. I want veterans to have their choice. I want veterans to be able to get, again, the benefits they have earned. These are earned benefits for our veterans in exchange for their services. This is about, for me, removing unaccredited, unregulated claim sharks who target veterans for those earned benefits. We'll also hear that these companies assert they provide better, faster service to veterans. In fact, that's one of their principal lures. Okay, I do understand that. I understand why that could be enticing to a veteran. One, the VA is processing claims faster. Two, let's make sure that these appeals aren't so attractive anymore, that the veterans are actually able to access the benefits they've earned. There's been a lot of robust hiring at the VBA facilitated by the PACT Act. Let's make these claims easier to navigate. That's what we're all looking for here. I think most troubling, though, is we're going to witness some Olympic-level displays of mental gymnastics today from those companies trying to rationalize how their activity isn't illegal, when it is, and has been for decades. They have the option to be accredited, but have chosen not to do so, which, by the way, the accreditation is free. So if the process is cumbersome, we should prioritize finding a solution to streamline it, so we can offer more choices to veterans while keeping their earned benefits where they belong, with them. I agree with the chairman. It's ridiculous that a veteran is paying $30,000 to have somebody navigate a claim for them. I think it's ridiculous that the claims are too difficult to access, that veterans feel they need someone to help them. And I think it's the job of this committee to help our veterans. So I want to take a step back, actually work through what works best for them, absent of consideration of what works best for the companies who are purporting to support our veterans, but who are in fact taking tens of thousands of dollars, sometimes from each veteran, and hundreds of millions of dollars overall. I yield back.
Thank you, Mr. McGarvey. This morning, we have colleagues who will be testifying from the dais about the bills they have sponsored. General Bergman, sir, you're now recognized for 5 minutes to speak on the PLUS Act.
Thank you, Mr. Chairman, and thank you to our witnesses for being here today, and to Chairman Bost and the entire VA committee staff for their work on the issue thus far. I'd like to start by stating I firmly believe that everyone present today, on both sides of the aisle, have the same fundamental goal: to prevent and punish bad actors seeking to take advantage of veterans, and to ensure that veterans are able to quickly and easily receive the disability benefits they deserve. Congress must take action to ensure that veterans looking for help navigating the VA disability benefit system are not defrauded or otherwise taken advantage of. However, This cannot come at the cost of removing veteran agency and choice. It would be unacceptable for Congress to push a heavy-handed ban on the entire industry of legitimate businesses, often veteran-owned, that have helped thousands of veterans get the claims they deserve. The Plus for Veterans Act, which I introduced along with my friend Lou Correa from California, will preserve the right for veterans to get help from the private sector while preparing VA applications by incorporating these businesses into the VA accreditation system, all while imposing penalties on bad actors that seek to exploit veterans. By incorporating these businesses into VA accreditation, veterans will have protection against the abuse and recourse if they are taken advantage of, and VA will have the teeth it needs to punish bad actors. Contrary to what some have claimed, no veteran would ever be forced to pay a fee to obtain the benefits they've earned through their service under the PLUS Act. In fact, the bill creates new requirements for veterans to be informed of free options for getting assistance with their disability benefit applications, for instance, through the VSOs. This is on top of the new safeguards in the bill that prevent high fees, require informed consent in clear language, and prevent conflicts of interest between agents and doctors who provide medical evidence. There will also has been new additions and improvements made to the bill text following constructive feedback we have received over the past 2 years. Most notably, the bill now establishes a system of provisional accreditation that will allow new agents to begin assisting veterans in a timely manner while ensuring the veteran remains protected from abuse. It also establishes steep penalties for any malpractice by agents with provisional accreditation, including a fine of up to $50,000. I remain open to constructive feedback and good faith dialogue as we work to craft the best legislation possible. In regard to concerns related to the fee cap structure included in the PLUS Act, I would like to make the following points clear. First, any imposed caps on fees by accredited agents must be set at a level designated to protect veterans from abuse, not at a level that effectively sets the price for the entire market and forces out high-quality, good-faith businesses. Secondly, there is existing federal precedent justifying a fee cap like in the bill. For example, the Social Security Administration's fee cap for assistance on disability claims is currently set at $9,200. And yet assisting with VA claims is far more complicated and time-consuming than with Social Security. Social Security disability claims do not have to prove service connection. There's no 0 to 100 disability rating like with the VA, and the requirements for obtaining National Social Security Advisor certification are far lower than that of the VA accreditation. It would be nonsensical to impose a cap at or below that of Social Security's given all the additional complications and costs involved in helping navigate the VA. Finally, the projections created through the PLUS Act, like providing information on free assistance options and incorporating all agents into VA accreditation, are fundamentally designed to provide veterans with a fair and well-understood choice. If a veteran decides that they would like to pay a fee in order to get easier, faster, and more personalized assistance in filing their claims, who are we to tell them that they can't? Veterans should be allowed to choose whatever option they decide to do in their best interest. Filing on their own, going through a VSO, or through a private business, and adding overly draconian fee caps will only limit the number of choices available to them. The PLUS Act for Veterans recognizes that veterans are capable of choosing what options are best for them when seeking assistance in obtaining benefits. Denying this right is not protecting veterans. It's this is a strong word, a lot of syllables for a guy like me, infantilizing. It makes them feel like little babies. How's that? How's that? I mean, you know, that's Marine and Navy speak, but I don't know if the Air Force, you get it, right? All right. I look forward, by the way, I'm going to have to make sure that that is never in a speech again. I'm going to have to look forward. Can I close now?
You should let the enlisted
Okay,
man
with that I yield back.
Yes, sir. Thank you, General. Mr. Pappas, sir, you're recognized for 5 minutes.
Thank you very much, Chairman Luttrell and Ranking Member McGarvey, for your opening comments, and General Bergman for yours as well on your legislation. I want to share with everyone today about information about my bill, the Guard VA Benefits Act. This committee has heard me and many of my colleagues and veteran service organizations talk about this bill and reference the troubling increase in unaccredited representatives that are looking to profit off veterans' disability claims. They peddle a for-profit model that veterans can receive free of charge from veteran service organizations like those who we will hear from today. One Navy corpsman we heard from paid a company $8,000 to help her access her disability benefits after she left the service. Another Navy service member said he was charged almost $10,000 for just 6 hours of virtual coaching that he later said he could have found online on his own. So it's alarming because the more third parties that have a hand in a veteran's claim, the more potential exists for fraud and abuse, which I'm sure we all agree we want to prevent. So to provide veterans with qualified and competent help and protect them from individuals who may be targeting their benefits, VA has long operated an accreditation, discipline, and fees program to provide oversight of those who assist with fee preparation. Under the current law, VA-accredited representatives are the only individuals authorized to prepare, present, or prosecute VA claims on a veteran's behalf. Unfortunately, in 2006, Congress decided to strip VA of its ability to penalize those who violate the longstanding prohibitions on preparation, presentation, and prosecution of a VA claim before VA. Since then, the claims consultant companies have exploited this dangerous loophole to rake in millions of dollars from veterans across the country. This bill is simple. It will reinstate criminal penalties for unaccredited claims representatives. It does not create new criminal acts, nor does it change the well-established definitions of preparation, presentation, and prosecution. So to that point, I want to be clear. The gathering or development of third-party medical evidence has long been excluded from the definitions of preparation, presentation, and prosecution. The GUARD Act does not change that dynamic, nor would I propose to. I also want to address another argument that some have raised, that the GUARD Act would somehow limit the choices that veterans have with their claims. Some companies have even hired expensive lobbyists and lawyers to argue that this bill would violate First Amendment rights. Nothing could be further from the truth. This legislation does not ban a veteran from choosing whoever they want when seeking help with their VA claim. If veterans want options, they can talk to any number of professional, well-trained veteran service officers. They can seek help from VSOs like the VFW, the American Legion, and others. And if veterans want a paid option, they're free to turn to agents and attorneys who are accredited for help. The difference is that all of these individuals are accredited. They go through that process. They're subject to the oversight of VA and the Office of General Counsel. And it's exactly that oversight that for-profit claims consulting companies are seeking to continue to avoid. So these claims consulting companies, they know what they're doing is beyond the scope of the law, and they have spent thousands and thousands of dollars lobbying against this bill. They also know that there's nothing stripping them or preventing them from becoming accredited today, except that they will not make as much money under unaccredited if they become accredited. So I just want to say that I look forward to working with my colleagues on developing a permanent solution to this. I think it must include ensuring that we reinstate criminal penalties. And I look forward to hearing from folks on our panel about this and other bills under consideration today. I want to commend the continued support of veteran service organizations in assisting the veteran community and in speaking out strongly for this legislation. We have strong bipartisan support in the Congress. The bill has been reintroduced, and I'm looking forward to working with my colleagues on a solution that's going to protect veterans, make sure that they can keep their earned benefits, and ensure that we are moving forward in a way that is worthy of the service and sacrifice of so many in this room and across the country. So with that, I yield back my time.
Thank you, Mr. Pappas. It's good to have you in here again, sir. It is our practice. We will forego a round of questioning for the members. Any questions may be submitted for the record. I now invite our second panel of witnesses to the table, if they are present. Welcome, everyone. Yes. Mr. Smith. Colonel, go like this. It's on the record. It's got to be right. Apologies. Thank you, sir. Now, welcome, and thank you for joining us today. Our second panel includes Mr. Josh Smith, Chief Executive Officer of Veterans Benefits Guide, Lieutenant Colonel Bill Taylor, Co-founder and Chief Operating Officer of Veterans Guardian VA Claim Consulting, Mr. Peter O'Rourke, President of the National Association for Veterans Rights, Ms. Diane Boyd Rauber, National Organizations of Veterans Advocates, and Mr. Pat Murray, Acting Executive Director of Washington's Office, Veterans of Foreign Wars of the United States. I ask all the witnesses please rise and raise your right hand. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Be seated. Let the record reflect that all witnesses answered in the affirmative. Mr. Smith, you're recognized for 5 minutes, sir, to deliver your opening testimony.
Joshua Smith, and I am the CEO and co-founder of Veteran Benefits Guide. I would like to thank Chairman Luttrell and Ranking Member McGarvey and other committee members for providing me this opportunity to share my perspective. I'm testifying today in opposition to the GUARD VA Benefits Act and in strong support of the Plus for Veterans Act. I want to thank Representative Bergman for introducing the Plus Act and Representatives Mace and Sell for co-sponsoring the bill. VBG also supports the discussion draft that has been shared and believes it represents a reasonable compromise. While well-intended, the GUARD Act would severely and unfairly limit choices veterans have in seeking assistance with their claims. Instead of only targeting bad actors, it would make it illegal for veterans to get advice or assistance from any private services, including honorable companies like VBG. We believe the veterans need more help in getting their benefits, not more limitations on their options and choice. In contrast, the Plus Act and the discussion draft provide the right balance between establishing guardrails to protect veterans from bad actors and ensuring private companies are allowed to continue serving veterans. Each of these bills includes strict disclosure requirements, fee caps, and privacy protections that we support. Opponents of the Plus Act and the discussion draft inaccurately claim that organizations such as ours choose not to be accredited. This is false. VBG would welcome the opportunity to become accredited. The Plus Act and the discussion draft legislation would resolve this issue by providing a pathway for accreditation, allowing VBG and other good actors to come under the oversight of the VA. The fact that VBG is not currently accredited does not mean we are violating federal law. We provide specially trained case managers to guide veterans through the claim process, but we do not act as a veteran's agent or representative, and we do not present before the VA. We believe federal legislation is needed now to resolve this issue. Different versions of the GUARD Act and Plus Act have been introduced in at least 30 states. Without a federal solution, the result will be a chaotic patchwork of state legislation. Our nation's veterans are being harmed every day by this chaos, and gridlock is allowed to continue. This is not a partisan issue. In states where these bills are being considered, we have heard from Democrats and Republicans expressing a desire to reach a compromise that both protects veterans and preserves choice. In addition to being the CEO of VBG, I am also a Marine Corps veteran and a former VA employee. At the VA, I witnessed firsthand that veterans were being denied benefits they earned. That is why I left the VA with my wife Lauren, created VBG to help guide veterans through this complicated process. We have grown our company and have now more than 200 employees with offices in Nevada and California. Roughly 80% of our employees are veterans or immediate family members of veterans, and we employ former VA personnel like myself, helping to assure we keep up to date with VA regulations and training. It is clear that our service is needed. Despite their best efforts, veteran service organizations do not have enough manpower or resources to keep up with the demand for help. In congressional testimony, the National Association of County Veteran Service Officers acknowledged that they face disparities in staffing levels, technology, education, and outreach, and have become even more acute in recent years, and that they are scrambling to meet an influx of requests from veterans for support. In fact, more than 70% of our clients first navigated the process with the help of a VSO. They were either denied their full benefits or felt the process was taking too long, continuing to submit claims. VBG's sole focus is getting the veteran's claim right the first time, avoiding the need of a lengthy and costly appeal. The value we bring to our veteran clients is best reflected in their own words. Leo, an Air Force veteran from Nevada, stated the following, and I quote, "There are some organizations out there that say, don't go to these companies that you have to pay for. You should be doing it on your own. And my argument is I did go on my own and try to file my claim, and I did not get help. Many people, including VSOs, promised to help me, but they didn't actually help. It wasn't until I found VBG that I got the rating I deserve. If it's my money, it should be my choice what I do with it. I want every veteran to have the ability to make that choice," end quote. With reasonable guardrails in place, we believe that veterans should be free to contact with whom they wish for help. This was the guiding principle in 2006 when Congress loosened restrictions on veterans being able to pay for help with their appeal claims. It should be the same guiding principle today. Thank you for considering my testimony. I would be happy to answer any questions.
Thank you, Mr. Smith. Colonel Taylor, you're now recognized for 5 minutes, sir.
Good morning, Chairman Luttrell, Ranking Member McGarvey, and members of the subcommittee. My name is William Taylor, and I am the co-founder of Veterans Guardian, a West Point graduate and a 23-year Army veteran with 6 operational deployments. I am proud to have served my country and co-founded one of the largest veteran-owned and operated companies helping veterans navigate the VA claims process. In my written testimony, I've included a detailed description of my military service and my company, but for now, I'd like to dive right into the issues. The bottom line is we are veterans helping veterans. We provide a valuable service and are committed to serving veterans. Candidly, I am frustrated to have my integrity and honor regularly called into question by those who label me a claim shark simply because I use a different approach than the traditional model, and that approach is often preferred by veterans. I have remained committed to finding a compromise that modernizes accreditation and ensures veterans have choice in claims representation. I once again extend an offer to all entities at this table to work together and find ways to compromise without resorting to mudslinging. The unfortunate reality is that many veterans face difficulties navigating the VA disability process. It cannot be ignored that there are currently over 935,000 claims awaiting adjudication by the VA. Contrary to the views under the Biden VA, the current systems do not meet the needs of veterans. Veterans need more options, not less. To address veterans' needs, they should be able to pursue their claim in the manner that best serves them with full knowledge of all available options at any step in the process, including free and fee-based options. I'd like to address the allegations that my company is breaking the law. Nothing could be further from the truth. Section 5901 of Title 38 contains the foundational rule governing claims assistance. It states that no individual may act as an agent or attorney in the preparation, presentation, or prosecution of any claim under laws administered by the VA, unless such individual has been recognized for such purposes by the Secretary. The agent or attorney qualifier is also included in the statutory limitation on when fees may be charged for assistance under Section 5904. Veterans Guardian does not act in either role. We do not employ attorneys, so that category can be set aside. Our employees do not act as agents. We provide advice to our clients, but we do not file claims, we do not interact with the VA on the veteran's behalf, and we do not represent the veteran before the VA. For those reasons, we are not acting as an agent or attorney as required to meet the federal restriction on claims assistance. We also do not violate restrictions on assignment of benefits. Veterans Guardian never acquires a right to receive our clients' VA benefits, which is what the law prohibits. Rather, clients pay us a fee equivalent to 5 times the increase in monthly benefits obtained using our help. The fact that the amount a veteran pays Veterans Guardian is based on the increase in benefits does not mean that the company acquires the right to receive those benefits from either the VA or the veteran. A veteran can pay fees to Veterans Guardian out of sources that are completely segregated from benefits distributed by the VA. And once they start receiving benefits, they can pay our fees in a lump sum or on a flexible schedule that is independent from the VA's payment timeline. In other words, veterans pay a fee for our service. They do not transfer their benefits to us. Even though our business is compliant with current law, it's become clear to me that maintaining the status quo is not sustainable for all parties involved. Divisive debates over the years have not served veterans. Our focus should be on finding solutions that make the system work better for veterans. H.R. 1656, introduced by General Bergman and Congressman Correa, does just that. It would allow companies like mine to become accredited rather than legislating us out of existence. It improves oversight and ensures veterans are receiving competent assistance. It provides veterans the freedom to make informed decisions on how they want to pursue their claims. The HVAC committee discussion draft is also well-intentioned and a step in the right direction, and we have provided amendments for consideration that would enable our full-throttled support. As for the GUARD Act, we support the intentions of the bill, but the execution is flawed and has failed to receive a markup in 6 years. Despite what some may allege, there is no sweeping momentum for GUARD-style bills in the states. GUARD-style bills were defeated in 20 states in 2024. In the last 2 years, only 2 states have passed laws that fully deny veterans the choice to use a private company: New Jersey in 2023 and Maine in 2024. Both laws are being challenged in court. While Congress is certainly not bound by the developments in the states, I believe conveying what's factually occurring in the states is important. I look forward to a constructive discussion regarding the bills on today's agenda and how all of us should be working together to address the issues that veterans face and to provide veterans with more options and protections from predatory practices. I look forward to remaining engaged in working with you, your staffs, and the other parties as we address these important issues for our nation's veterans. Thank you, and I'm happy to take any questions.
Thank you, Colonel Taylor. Mr. O'Rourke, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member, members of the committee. I appreciate the opportunity to testify before you today. My name is Peter O'Rourke, and I'm the president of the National Association for Veteran Rights, NAVR, former acting secretary and chief of staff of the Department of Veterans Affairs, a veteran of the Navy and the Air Force. And I'm honored to be here to provide testimony addressing the legislation that your committee is considering today. For the past 4 years, I've been part of a critical conversation, one that should be centered on veterans' rights, yet instead became a battleground over whether they should have the freedom to choose alternatives outside the Department of Veterans Affairs or the traditional VSO model when seeking their service-connected disability benefits. In a world evolving at breakneck speed, it's truly astonishing to me that some would argue against applying technology, innovation, and new ideas to improve veteran services. But here we are, clinging to outdated systems, resisting progress, and defending the past at the expense of the future. Over those 4 years, those who dare defend the notion of private sector assistance, many of whom are veterans themselves, have been vilified, slandered, and relentlessly attacked by the very institutions supposed to support and protect them. I have to ask, why do these groups believe they alone should dictate this conversation? And believe me, they do. I was there in the 2023 Hill Summit when these groups shouted down a veteran who was describing his long, agonizing struggle to obtain a correct disability rating. I read op-eds from the same veterans groups that shamelessly accuse their fellow veterans of fraud, and even worse, wrongfully painting them as criminals, while simultaneously pushing legislation that would actually criminalize the assistance these veterans provide their fellow brothers and sisters. I've personally been accused of running a criminal organization by senior members of veterans groups that oppose our position, a position that simply stands for veterans' choice. I have spoken with countless lawmakers across the United States who relay to me the lies, half-truths, and self-serving attacks that they have heard from those who want to maintain their monopoly over this process. But why? 2021 brought the first signs of resistance to the industry, but the oldest of these companies had already been operating for nearly 7 years when the first version of the GUARD Act was introduced in the Senate. Some of these companies heard the rhetoric then and simply believed that there was a misunderstanding, that if they would just explained why veterans were choosing to pay for these services, if they just told the stories they were hearing from veterans, all concerns would be alleviated. But the companies never were given a fair chance to tell these stories. Unfortunately, opponents of veterans' choice, many of them are here today, have taken a divisive me-first approach to debating this topic at the expense of a veterans-first approach. The results have been predictably unproductive because both sides have fought to have an utter stalemate, and an unfortunate inaction forced honorable companies to take matters into their own hands. From this inaction, companies in the private benefit space created NAVR to fill the accountability void that remained from the ashes of this long and unrelenting fight. And despite all these efforts to destroy the industry, veterans are still utilizing these private companies. Veterans choose these companies because they're tired of being let down by a giant bureaucracy, and they choose these companies because they're tired of hearing excuses. Many of these companies have helped tens of thousands of veterans and have thousands of positive reviews that describe the quality and satisfaction that veterans have with these companies. They are truly accountable to the veterans that they serve. Because Veterans' Choice has been resoundingly positive policy, and because President Trump's agenda seeks solutions of tomorrow to solve the problems of yesterday, there's only one piece of legislation that will be discussed that meets this definition. The legislation is the PLUS Act, which preserves veterans' choice, creates guardrails and common sense rules that put veterans' needs first. This is why NAVR enthusiastically supports the PLUS Act. In closing, this industry has grown over the past decade, employing thousands of veterans, including many veterans, and has helped tens of thousands of veterans secure their correct service-connected disability rating. This didn't happen because veterans are being misled or defrauded. Let me be clear, we're talking about veterans. They're not naive, they're not being fooled into seeking this help. No, veterans are making conscious, informed decisions to seek help outside the VA's current system, and no one should be outraged that they now have a choice. The real question isn't whether these choices should exist, it's how we ensure that they work for veterans, not against them. My hope is that both sides of this debate can come together to pass common sense legislation like the PLUS Act so that we can move forward, work as partners, and take the next step of challenges facing our nation's past and present warfighters. Thank you, and I appreciate answering any questions.
Thank you, Mr. O'Rourke. Ms. Roberts, you're recognized for 5 minutes.
Thank you. Chairman Luttrell, Ranking Member McGarvey, and members of the subcommittee. NOVA appreciates the opportunity to appear before this subcommittee and share our expertise regarding VA accreditation and ethical representation of veterans. Our accredited members live, work, hire, and represent veterans, family members, survivors, and caregivers in your states and districts. Many are veterans, military spouses, or members of veteran or military families. Title 38 of the U.S. Code is clear that only accredited persons may assist veterans with their claims and appeals. Moreover, only accredited individuals should be lawfully allowed to assist veterans because it provides for regulation of those individuals and recourse for veterans. Unaccredited claims consultants want you to codify the business model they have used for years in violation of Title 38. Today's hearing centers on whether the law should be changed to allow a veteran to hire a representative at the initial claim stage. And if so, what is the most veteran-centric way to do so? Since providing veterans with the right of judicial review in 1988, Congress has decided 3 times to expand the conditions under which veterans can hire accredited attorneys and agents for representation before VA. Each time, Congress amended the triggering event, but left the basic fee model intact. Most recently, in 2017, when passing the AMA, Congress declined to move the triggering event to initial claims. Why? Because VA has long maintained it must have an opportunity to decide an initial claim before paid representation is available. This is based on the statutory requirement that VA must assist the veteran in developing the evidence to support an initial claim, which is at the heart of the non-adversarial process. Should Congress conclude that the time is right to expand choices for paid assistance to veterans, the simplest option is to again move the line by revising 5904 to allow for charging at the initial claim stage. Such an amendment, discussed at length in our written statement, is most veteran-centric. NOVA does not support charging veterans prospective fees that would frequently result in a veteran owing more than they receive in their retro payment. NOVA continues to support GUARD and the return of penalties to the statute. We also support the provisions of PLUS and the discussion draft that emphasize Title 38 preempts the patchwork of disparate state bills currently under consideration that propose to regulate this area. NOVA does not support any system that would allow for unaccredited assistance or would create tiers of accredited representatives who handle only initial claims or only post-initial decision work. Such a model would force a veteran who is completely happy with a representative to seek a new one for further assistance if VA does not fully grant the claim, which is a regular occurrence. This is inefficient, ineffective for veterans, and the opposite of choice. Unfortunately, we must again address absurd charges made against our members. These companies are attempting to distract you with uninformed and misleading accusations that attorneys and agents purposely delay cases to earn higher fees. Let's be clear. This is against VA's standards of conduct. VA can cancel the accreditation of anyone who delays a proceeding without good cause. State bars can discipline their members. Veterans who believe their accredited representative has violated standards or does not deserve a fee has due process and recourse through VA and through the state bars. There is currently no due process or recourse for veterans who have been harmed by unaccredited actors. Let's put the intentional delay myth to bed once and for all. The reality is the VA claims adjudication process takes time. According to testimony, these companies have been assisting veterans with claims for a decade. There's been, in fact, no appreciable reduction in the need for our members' assistance appealing adverse decisions, and also no proof these companies' model or involvement has promoted greater accuracy or reduced any backlogs. NOVA has worked for many years with VA Congress and other stakeholders to improve the adjudication process. We push for quality and timely decisions for veterans and have appeared before this committee several times to offer information and solutions. We remain committed to continued collaboration on these efforts. Finally, NOVA will be holding a conference this September here in DC. We usually invite your staff to stop by and sit in on any sessions of interest. Please consider this an open invitation to all of you to come, meet NOVA members from your states, and hear firsthand about what they do to improve the lives of our nation's veterans, family members, survivors, and caregivers at every level of the claims and appeals process. Thank you again for the opportunity today, and I would be happy to answer any questions you have.
Thank you, Ms. Rauber. Mr. Murray, sir, you're recognized for 5 minutes.
Thank you. Chairman Luttrell, Ranking Member McGarvey, and members of the subcommittee, on behalf of the men and women of the VFW, thank you for the opportunity to provide remarks today. The VFW continues to lead the charge against unaccredited, unscrupulous actors we call claim sharks, who charge service members, veterans, and survivors illegal fees. Our resolutions urge Congress to pass legislation that protects VA beneficiaries from predatory companies and individuals attempting to bypass the VA accreditation system and monetize the disability and death benefits of veterans and surviving families. Due to the stalemate in Washington, D.C., our members have worked to pass state-level legislation that installs consumer protection to enforce the federal statute. Currently, 9 states have laws that prohibit charging fees that are not allowed by federal law and have various degrees of penalties. Washington, Iowa, Michigan, New York, Illinois, Nevada, New Jersey, Maine, and Massachusetts have laws that require anyone who charges fees to do so adhering to federal law and regulation. Conversely, one state, Louisiana, allows charging up to $12,500 for an initial claim. The VFW has expressed to the committee our red lines regarding accreditation, any accreditation bill put forth. Veterans should not have to pay future benefits, active duty service members should not have to pay for claims, and no one who prepares a claim should have any financial affiliation with medical examiners that could possibly affect the outcome of the claim. These are common sense concerns that we insist be in any bill advanced by this committee. In fact, VA agrees that payments of future benefits are not allowed under current law. In a November 2023 letter from VA in response to a bipartisan bicameral congressional inquiry, VA was asked, what is VA's official position on contracts in which a veteran agrees to pay a product of the increase in future benefits? The response was, where a contract ties the existence and extent of a claimant's payment obligation to the award of VA benefits, it is logically construed as contemplating those benefits as the source of the payment. The statute allowing for the payment of fees to VA-accredited attorneys and agents for the preparation, prosecution, or presentation of VA benefits claims from past due benefits is considered an exemption to the prohibition on assignments set forth in Section 5301. But under current law, even this exemption does not go as far to allow for an agent or attorney to contract for the payment of fees from a claimant's future benefits. VA also stated, in addition, they have concerns that would heavily depend on the different fee structures that could be proposed. For instance, a fee based on a product of the monthly benefits award, such as 5 times or 500% of the amount of monthly increase of benefits, would likely be unreasonable or worse, predatory. They go on to state further, a flat fee limit such as a cap of $12,500 for services provided on an initial claim seems excessive and thus unfair to veterans. These are VA's words, not the VFW's. Unfortunately, VA is not here to present those views, so I'm doing that for them. The VFW strongly supports the Guard VA Benefits Act that seeks to reinstate penalties. We assert that this legislation, which adds only one sentence to Title 38, is a sound policy proposal that simply institutes a penalty for breaking current law. Anyone who claims to be adhering to federal law should not be opposed to being subject to penalties of said law. This would signify a substantial step forward, holding bad actors accountable to the intent of the law. In fact, VA has stated that in its budget request, each year in its legislative proposal section, since 2018, when Mr. O'Rourke was the acting VA secretary, They have asked for that legislative proposal in their budget request. We agree that that would be beneficial for veterans and survivors. The VFW opposes the PLUS Act because of the concerns VA has with the components of that proposal, such as allowing assignment of benefits and unreasonable fee caps. The VFW agrees with those concerns. Chairman Luttrell, Ranking Member McGarvey, and members of the subcommittee, thank you for the opportunity to speak on these bills, and I'm prepared to answer any questions you might have.
Thank you, Mr. Murray. We'll move to a line of questioning. Thank you for your opening testimony. Mr. McGarvey, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Appreciate everybody being here today. I want to say one thing off the bat. Mr. O'Rourke, you said that people are outraged that veterans have a choice, and I just want to correct that. I'm outraged that veterans are feeling so desperate in getting their claims adjudicated that they're willing to pay tens of thousands of dollars to get those claims adjudicated. That's what makes me outraged. These are veterans who have earned these benefits, who have put on a uniform, who are willing to sacrifice everything for us, and they are feeling so stymied right now, they are willing to go to companies to pay this kind of money. That's what has me outraged. Let's get to the testimony. Colonel Taylor, page 6 of your testimony states, the PLUS Act lifts the outdated prohibition on paid representation for initial disability claims. It lifts the outdated prohibition. That sounds like you and I are in agreement that charging for assistance on initial claims is currently not legal, not allowed. The Code of Federal Regulations states also that, quote, no individual may assist claimants in the preparation, presentation, and prosecution of claims for VA benefits as an agent or attorney unless he or she has first been accredited by the VA for such a purpose. Now, I know in your testimony you said that you all do not act as an agent or attorney. Just to clear up some doubt, I just went to the Oxford Dictionary on my phone. An agent is described as a person who acts on behalf of another person or group, or a person or thing that takes an active role or produces a specified effect. You can see behind me how the VA defines preparation from this. In particular, but I'll read it for people around. Preparing a benefits claim generally includes but is not limited to consulting with or giving advice to a claimant or potential claimant in contemplation of filing a benefits claim, gathering evidence in support of a benefits claim on behalf of a claimant or potential claimant, or filling out VA forms for their submission to the VA. So we know what preparation means. We know an agent is someone who acts on behalf of another person or a person or thing that takes an active role or produces a specific effect. So when you look at this definition, when you look at the definition of agent, Colonel Taylor, I just have to ask you, is your company doing any of these things?
We fundamentally do not believe that we are acting as agents or attorneys. We acknowledge that we are helping with preparation. That is definitely clear.
But are you doing these things? In the preparation, are you preparing a benefits claim generally includes but is not limited to consulting with or giving advice to a claimant or potential claimant in contemplation of filing a benefits claim, gathering evidence in support of a benefits claim on behalf of a claimant or potential claimant, or filling out VA forms for their submission to the VA?
We are assisting with the preparation. We do acknowledge that. We do not believe that we are acting as agents. When you look at the definition of agency, agency typically requires 3 parties. The agent, who is acting on behalf of the client and engaging with the third party, which in this case would be the VA. We never represent the client, we never engage with the VA, and we never represent before the VA. And so we do not meet the 3 pieces of that triad that define agency. We are acting as a consultant that helps the veteran prepare to navigate the system on their own behalf in their own name. When we talked about lifting the limitations within the current law, that was in reference to what accredited agents or attorneys can do. And we believe that if we can change that, allow us to become accredited, we would like to work within and under the system with restrictions.
And I appreciate that. What you're talking about is a belief, and what I'm trying to talk about is a common sense definition of how we are representing people in preparation of a claim, which it very much sounds like you are doing. Whether you're helping veterans or not, that's not what I'm asking. That these are the current laws we have. It seems you are doing these things on behalf of these veterans, and that is not allowed under the current law. Mr. Smith, I have a question for you, and this is a very sincere question. We only have a minute. I'm gonna try and get through it very quickly. Right now, you could apply for free for accreditation to assist veterans. Instead, you're choosing not to do so. I do understand that the accreditation process can be time-consuming, so I'm granting you that. And I'm even gonna go so far as to say we should tweak that system, change the system, all right? But thousands of people have gone through it. My very sincere question to you is, why haven't you all?
Yes, thank you for that question. And that's exactly why we're here today, is to get a pathway for accreditation for companies, for our company to help veterans.
There is a pathway for accreditation. It exists right now, and thousands of people have used it.
Yes, and we are in full support of the PLUS Act or the discussion draft to.
But
create
why
an
haven't
additional
you
pathway.
gone through the pathway now? I mean, it's a very serious question.
During my time at the VA, I was preparing claims for a decision, and I was on the other side making the decisions for these claims. And I spent years doing that. I have much respect and for the VSOs doing it for free. I was a member of a VSO. They helped me with my claim, along with the VA home loan and also with education. My experience at the VA, I saw a wide variety of quality from the VSOs or from veterans doing it on their own, and it showed a big disparity between the training I received as a VA employee versus, and the expertise I know of the VA regulation, to how they were being represented from VSOs. I saw a big need for veterans to have the type of knowledge and expertise that I had as a VA employee, which is why I started the company. And I had no idea what it would have turned into. And for 5 years, it just grew by word of mouth. We have tens and thousands of happy
Mr. Chairman, I
veteran
know we're
clients.
out of time, and all I'm going to say is, I appreciate people trying to help, honestly trying to help veterans. I asked you why you haven't gone into the accreditation, and you just told me how good your company is, but that didn't answer the question. So that is something I want a sincere answer to the question to at some point. Thank
Yes,
you,
sir.
Mr. Chairman.
Thank
I
you.
yield back.
Mr. Bergman, you recognize, sir.
Thank you, Mr. Chairman. Can I take a point of personal privilege before my time starts?
You may.
All right. I figured out why I couldn't pronounce infantilizing. It's got 5 syllables. I'm limited to 4. I just wanted to let you know that, so I apologize. I'm going to make sure my note writers, we limit it to 4 syllables. Okay, I'm ready for the clock to start. Let's get to the point very quickly. I heard my colleague talk about protecting veterans. And when I think about protecting things, whether it be our country, our little children, or our people who need assistance, we have to be very careful, I believe, that when we try to protect someone, we don't limit their ability to become independent. So I would suggest to you we have to be very careful here as a committee in what we do in oversight and what we do as we look at things to don't let protect be the roadblock that enables independency on the part of the marketplace and the part of the veterans to interact with them. So with that, Mr. Taylor, I'll start with a simple question. Does any part of the PLUS Act force veterans to pay a fee to receive assistance in obtaining their disability benefits?
It absolutely does not, and one of the things that we appreciate about the PLUS Act is that it maintains the veterans' freedom of choice. They can pursue a claim on their own, they can pursue it with the VSO from one of the veteran service organizations or a state or county employee or their congressional office, or if they choose that those services are not meeting their needs, they can choose to use a private service like ours.
Okay, and I don't think anybody in this room disagrees, with the fact that we need to accredit anybody in any place. Doctors need to be accredited. Pick your teachers need to be accredited. They need to show that they can do the job. Can you speak to the need for changes to the accreditation application system, for instance, through the temporary and provisional accreditation included in the PLUS Act?
Thank you, sir. We do agree with the requirement to be accredited. We do believe that accreditation needs to be open to allow people to help at any step of the process, and that's really the limitation to becoming accredited right now. What's proposed in the PLUS Act would provide a provisional path to allow us to become accredited, to operate within the system, but also provides immediate protections that if we violate any of the rules, there's a heavy penalty that will be enacted if we do not act properly under the rules of the PLUS Act.
And I know we're going to, because this is going to, I had a zillion questions for all of you, but we're going to stay focused on here. What steps, Lieutenant Colonel Taylor, what steps does Vets Guardian take to make sure veterans can pay the fees they agreed to without placing financial strain on them or their family?
We have developed a payment system that ensures that no veteran is financially disadvantaged from where they were when they started working with us. We do not believe in collecting fees until we have validated that the veteran is getting their new benefits from the VA, and that we believe that any benefits any fee that is paid to us should be paid out of new benefits that the veterans are receiving. We would be happy to see additions to this bill that would codify some of those rules, require fees to be contingent on a successful outcome, and require them to only be collected after the veteran is collecting their benefits.
Okay, so you've developed your business model and how you're going to do this. Would you be open to adding additional guardrails? Because we do, part of what we're looking here to do is to create guardrails and guidelines. Would you be open to additional guardrails to plus ensuring agents who charge fees take steps like what you just articulated?
Yes, absolutely. For the last, since I've been engaged in this process, we have been open to common sense guardrails. We do understand there's predatory practices and that we need to protect veterans, and we are open to anything that addresses those concerns.
Okay, thank you. Mr. Murray, got a couple of just, let's yes or no questions. Does the VA accreditation system adequately ensure agents are held accountable to veterans and the VA?
I wish VA was here to answer that.
Yes or no?
I can't say no.
No. You are providing a perspective based upon your knowledge, your in-depth. So, I'll repeat it. Does the VA accreditation system adequately ensure agents are held accountable to veterans and the VA?
We believe the system can.
Does the VA accreditation system adequately ensure agents? Yes or no? Because you're looking at, you're very deeply into it. Or maybe simply, do you think it can do better?
It can always do better.
Okay, is it doing good enough now?
I don't think so.
Okay, thank you very much, and I yield back whatever second.
Thank you, General. Mr. Pappas, sir, you're recognized.
Well, thank you, and I appreciate everyone's testimony and the conversation here, and I really do hope we can have a deliberative process as we move forward to figure out legislation that is going to address this issue. And I started from this, hearing about it from constituents, hearing about it from veteran organizations, about the problem that does exist out there, where veterans are being charged exorbitant fees to get access to the benefits that they have earned. And many have talked about deceptive practices along the way. That's a problem that I believe this committee needs to work to address, and we should do it by strengthening the accreditation program and passing my bill, which would put in place those criminal penalties that were stripped out of the law in 2006. Now, we heard from companies, and others have said that we don't participate in the preparation, presentation, and prosecution of VA claims. And if that's the case, then there's nothing to worry about with respect to reinstating criminal penalties for those that are running afoul of the law. So I think my bill is pretty simple and straightforward. Mr. Murray, I wanted to turn to you and just ask about your team and the work they do to get accredited and to do the work that they do. Just help us understand a little bit about what goes on in terms of your organization and assisting veterans with claims.
Sure. So thank you for that question, Mr. Pappas. As VSOs, we have to go through 40 hours of training. A lot of it now can be done self-paced online. You need to pass a test, with a certain percentage correct, and then pass a background check. That's just the process for veteran service organizations. The accredited attorneys and accredited agents have a different process as well.
Can you talk about the difference between pre-filing consultations and claims preparation? We heard a little bit about this today. Companies are arguing that because they don't actually hit the send button on a veteran's application, they're not actually assisting in preparation. How do you view that issue?
So we view not physically mailing the claim itself. That's not the only part of preparing a claim. As VA stated, it's gathering evidence, contemplation of a claimant, providing assistance and advice. We believe that is also part of the preparation because You're preparing the entire package. I know that legally preparation has a certain definition. We feel that the whole part of that is preparation, as does VA.
Mr. McGarvey talked about frustrations that veterans have in terms of delays in getting claims processed, in getting their benefits, and I think that's an issue we have been working on. We have to continue to address. Obviously, we've asked VA to do more in passing PACT Act and other legislation that has put a lot of pressure on the workforce at VA. I'm wondering if you can talk about capacity within the VSO community, within the accredited agents and attorneys that are out there. Do we have enough capacity to deal with some of the new authorities that Congress has given VA?
I don't think so. There are a lot of places where the entire system can get better. The VFW is not saying that we can do this on our own. We're supported by an entire network of county VSOs, state VSOs, our other partners like the American Legion and DAV, and accredited agents and attorneys. There are places all around this country that can invest more in helping with those services, but nothing that we're talking about today, whether it's the GUARD Act or the PLUS Act or the discussion draft, will make VA process these claims any faster. The backlog, does exist. There are claims that are waiting for adjudication. Nothing on our front end is going to make that any better. A fully developed, fully prepared claim will hopefully get through correct the first time, but it's up to VA to process that. No one sitting at this table can speed up the actual process itself.
Yep, that's the other essential element in this conversation. Ms. Boyd-Robert, can I turn to you? I appreciate your reflections on the legislation before us today. You did say there were elements of the PLUS Act that you could support, and I'm wondering if you could elaborate on that.
Well, we appreciate the fact that they want to put in the criminal penalties just as you do in GUARD. We also, again, have seen this move in the states to pass these different bills. GUARD, PLUS, it's extraordinarily confusing for veterans. It's confusing for advocates. We absolutely think there has to be something in there that emphasizes that federal law, this is a federal area of disability benefits, trumps and preempts the state laws.
And my time's up. I may have some other questions, but I yield back. Thank you.
Thank you, sir. Ms. Mace, you're recognized for 5 minutes.
Thank you, Mr. Chairman. As a daughter of a veteran, most of my family serves. I know how important it is to protect our veterans. So I applaud and thank all of our veterans. This is standing room only today. You men and women showed up, you served your country, you showed up to protect your benefits and get what you deserve. So thank you, and God bless you. My mission in life and my mission on this committee and other committees I serve on is to protect veterans. It's also to protect women. So I have some questions for Colonel Taylor, who's here today, this morning. Thank you for being here. What percentage of the benefits a veteran gets when they come through your company to get benefits? What percentage of their benefits does your company receive when working with veterans?
We do not work on a percentage basis.
How do you get your funds?
We charge a contingent fee that is equal to 5 times the monthly increase. That fee is only charged if the veteran has a successful outcome and receives an increase in their benefits, and we only invoice that fee once we validated that the veteran is getting their new benefits from
And
them.
what are your gross revenues for your company? How much money are you guys making every year?
We are a private company, and we do make a profit, but when we look at our fee structure,
Gross revenues.
my compensation is not publicly disclosed because we are a private
How much
company.
money is your company making every year?
I would be
90 million, 100 million, or more?
I would be
more or
prepared
less
to
than 100
discuss it
million?
offline. I'm not prepared to discuss that here today.
Of course not. All right. What percentage of your cases are fraudulent?
I would say that 0% of my cases are fraudulent.
So I have a question for you, a couple questions for you. What's your company's position on people who serve, well, don't serve, people who maybe attend a college or an academy for a year or two but never graduate and never serve and get 100% disability? What's your position on that?
That is not a position that my company should determine. That is a position that's determined by the VA and their regulations and the law and how that's administered.
Have you ever helped anybody who hasn't served like that maybe went to college or an academy for a year or two and got them 100% disability? Has your company ever done that?
I cannot speak on that. I would have to go back, but I could come back to you with an answer on that question.
I doubt you could. Would a football injury, someone who was at college or an academy for a year or two and got a football injury, deserve 100% disability, in your opinion?
In my opinion, no.
What if it was like from a car crash? Would they deserve 100% disability?
Once again, that's not for my
What if they
company.
just made it up and lied to get their 100% disability, and they only attended college or an academy for a year or two? What if they just completely 100% made it up and lied?
That would be a fraudulent claim.
If there was a fraudulent claim and there was an investigation, would you work with whoever's investigating it to ensure it doesn't happen again and to reverse the claim? Would you,
Absolutely.
All right, I have some ethics questions. So I understand your CEO, Scott Greenblatt, has a degree in criminal justice. Is that right?
I believe so, yes.
What's your company position on rape?
We are fundamentally against it.
What's your company position on voyeurism, women who are filmed illegally without their knowledge, permission, or consent?
Completely against it.
What's your company position on women who come forward to report rape
We fully support that.
or voyeurism?
We fully support that.
Would you work with anyone, would you work with a veteran who's accused of doing those things or something like it? Would your company ever want to affiliate with an individual like that?
We would not.
And you're saying you would not work with any students who try to get 100% disability who were at school for a year or two? Would your company ever work with any veterans who are being investigated for breaking the law?
I would, from a initial position, we should not. I can't say categorically that we haven't in the past, but we do not believe that's someone we should.
If you knew someone was being investigated, would you help them get their benefits if they were being investigated for heinous crimes against women?
We should not be, no.
You should not be. Thank you, Mr. Chairman, and I yield back.
Thank you, Ms. Mays. Dr. Dexter, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and to the ranking member for convening this hearing today. Thank you to our witnesses for coming, and to our room full of veterans for standing up for your benefits. Thank you for being here. No veteran should have to pay to file a claim to access the benefits that they have earned, full stop. Could we improve the VA claim system to make it faster and easier? Absolutely. That's why I'm here in Congress, to make sure that government works for Oregonians. But you know what I'm not here to do? Sit by while Elon Musk takes a chainsaw to veteran services or hands a blank check to industries ignoring the law. And I know that's true because I hold town halls and I listen. At my town hall on Saturday, the first person to speak was a Marine Corps veteran who was unjustly fired from the Veterans Benefits Administration. He had just taken a job. I know who I am fighting for, and that's why I support the GUARD VA Benefits Act. Last Congress, the GUARD VA Benefits Act had overwhelming bipartisan support, 221 co-sponsors in the House, 55 in the Senate, and backing from 44 bipartisan attorneys general, including those from every state and territory represented on this committee. Most importantly, it had the robust support from veterans and VSOs. Yet, instead of advancing this common sense bipartisan bill, we're here debating other proposals to put corporate profit ahead of veterans. A loophole that shouldn't exist is being exploited. And instead of fixing it, we're entertaining ways to help companies continue to take from our veterans. And to top it all off, the VA isn't even here to weigh in. Ms. Boyd-Robert, I'm sorry, I hope I said that right. Tell me, what does this committee need to do to make it faster and easier for veterans to file claims through the trusted, accredited system that exists?
Well, I think that Congress has constantly been looking at ways on how to make the system better. We really strongly believe in accreditation and making sure that everyone who is representing veterans is accredited, because that system requires people to become educated, to take the CLEs. Agents have to pass an exam. VA has to oversee all of these things. And in addition, for people who are charging fees currently under the system, they must submit every fee agreement that they sign with a veteran to the Department of Veterans Affairs, who always has the right to look at a fee and determine whether or not it's reasonable. So we really think that those safeguards are very critical to, protecting the system, protecting veterans.
Great. And Ms. Boyd-Robert, what risks do veterans face when they file a claim with an unaccredited company?
Well, again, because someone's not accredited, and to their points, they are standing in the shadows, coaching a veteran, consulting, but they're not the person who's going to put their name on a power of attorney and represent themselves to VA and say, I stand for this veteran. I'm the person you can contact when there's something wrong. I'm the person who's going to reach out to VA and say, this particular veteran needs to be advanced on the docket. So we just see it as accountability to stand up and say, I am representing this person.
Very good. So this administration claims it's tackling waste, fraud, and abuse. But again, they are showing their true colors. Taking money from veterans to pad the profits of unaccredited, potentially predatory companies quite literally writes waste, fraud, and abuse into the law. I will not entertain bills that seem more interested in protecting a so-called free market than ensuring veterans can access the benefits they have earned. Thank you. I yield back, Mr. Chair.
Thank you, Ms. Exter. Mr. Self, sir, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I'm actually delighted to hear that we're making progress toward the PLUS Act or the discussion draft. And I want to go back to a different situation, and it is the case that we have in VA that we've debated now for 2 years and it's veteran suicide. The VA wants to keep veterans in the big VA. There are veterans who want to go to a local clinic. There are veterans who want to go to peer-to-peer NGOs, counseling. They have choices. And here, I think I've heard that we agree that the accreditation process is inefficient and changes need to be made. So I always look to monopolies need to have competition. And I hope that we can reach agreement on whichever bill we can that will give our veterans choices, because our veterans need choices. So I'm not sure I have a question for our panel, but I want to say that I'm encouraged with the conversation here, and I think that at the end of the day, I look forward to our hearing, a true hearing on these bills, because I want our veterans to have as many choices in every area as they can have, because veterans are different, they have different interests, they have different needs, and so I'm actually encouraged here, and I want to see whatever bill this committee eventually advances, Mr. Chairman, will give our veterans a choice. Thank you. I yield back.
Thank you, Mr. Self. Dr. Morrison, you're recognized for 5 minutes.
Thank you, Mr. Chair. I want to thank you for holding this hearing today and thank our witnesses for being here. I also want to thank my colleagues for putting forward their proposals. I appreciate hearing the views and conversation that we're having. As the wife of an Army combat veteran and the daughter-in-law of a disabled Vietnam veteran, I know the VA claims process can be challenging to navigate. Since we're talking about benefits that veterans have earned, I think we need to make sure that we're helping them avoid paying out of pocket for what they're owed. It strikes me, too, that part of the challenge we're facing here is the increased and entirely appropriate need that the PACT Act is designed to meet. So the news that was leaked last night, the administration plans to fire up to 83,000 more VA employees, is perplexing to me at best and designed to gut the VA at worst. My question is for Ms. Rauber. In your testimony, you described the patchwork of state laws that have passed because of congressional inaction, frankly, on the issue. And it seems like it's not for lack of support. I believe last Congress, the Guard VA Benefits Act was co-sponsored by the majority of members in both the House and the Senate. So my question for you is, what are some of the other consequences that might result from further congressional inaction on these issues?
Well, I think that there's just more growth of these companies. They perceive that they are outside the bounds of the law. which we don't agree with because it would seem perplexing that Congress over all these years would have said, we don't want veterans to be paying for initial claims, and that by saying that they were somehow allowing for a loophole that would be this big. So we really think that there has to be some kind of action to sort of get a grip on what has become a growing industry.
Thank you. And this question has sort of been asked, but I'm hoping, Mr. Murray and Ms. Rauber, that you could share some recommendations that you might have on how what could VA be doing to make this process more efficient, besides firing 83,000 people?
And we think that would be harmful. What they have been doing, as we've seen, the backlog for claims cases, how long it takes, I believe it was about 146 days a week ago. It's slowly decreasing. The stories of claims taking 3 years to adjudicate is a thing of the past. We want to see that continue. So continuing to hire people at VA to review those claims to hopefully make it faster. We also would really appreciate things like adding additional resources to like our county VSO system. Right? There are plenty of states around the country that do great things. The Texas Veterans Commission is a great example. Not every state does that. We can here push out great resources to help other states do that so that there are so many more resources for veterans to show up and get that help they need.
And if I could add, in 2017, President Trump signed the Appeals Modernization Act, and that was the product of a lot of collaboration between Congress, VSOs, stakeholders, and it actually has made a lot of changes to the system that have greatly improved it. And I know this subcommittee is looking at even further improvements to the AMA, some things that need to happen, and we wholeheartedly support that and would love to, maybe get some of these issues passed so we can actually dig in on some of the meat of those.
I appreciate those answers. Thank you so much. I yield back, Mr. Chair.
Thank you, Dr. Morrison. Mr. Smith, do you believe that a veteran should be charged a fee for helping filing an initial claim for a presumptive disability that VA assumes is related to their military service?
Thank you, Chairman Luttrell, for that question. We do not believe that veterans should be paying for any presumptive claims. These are, in the spectrum of complicated cases, for VA claims, presumptives tend to be relatively simple. And
relatively simple. Don't ever say that again out loud.
Regarding what it takes to be service-connected versus a non-presumptive claim, in the scope of that, there's not as many prongs that need to be met in order for a presumptive condition to be met, and it's fairly automatic when you compare it to a disability you're claiming for military service. So for presumptive claims, we do refer them to veteran service organizations, and we refer all of our clients to any, that there are free services. The majority of our clients have used them, such as myself.
Ms. Rauber, as a trade association of law firms assisting veterans at no cost on initial claims, what guardrails do you think should be in place if Congress passes legislation that would allow charging fees on initial claims?
Well, we think that the current guardrails that are in place would be adequate. If Congress decides that they're going to allow for some charging system, then what is under the accreditation system currently is adequate. Everyone has to file a POA on every veteran they represent. Again, to my earlier answer, because then you're showing that you are the person that is representing the veteran. You have to do CLEs, you have to, if you're an agent and you're not an attorney, you have to pass an exam. You have to submit all your fee agreements to the department so they can look at them, and the department has the right to decide whether or not that fee is reasonable. So we think that the guardrails that are in place are solid ones. It's the determination that you all have to make as to whether or not you want to take that next step and allow for veterans to pay for assistance with filing their initial claims.
Mr. Murray, you were asked the question, is the accreditation process, does it need to be changed, advanced, or moved forward? You said absolutely yes. And then you were asked, what do you think about it? Actually, it's not good enough. So my question to that is, if it's not good enough, is it worthwhile at all? You have members in the hearing right now that don't have the accreditation. And Mr. Smith, your answer was absolutely out in left field. You're in the people's house, and we want answers, and that was not one, sir. So Colonel Taylor, I'm going to ask you, because if the other companies are getting accreditation for accountability, responsibility, and to be held accountable. I seem to think that that's what the accreditation means. But do you have one?
We believe
Does your company have, is your company accredited?
we are not accredited right now.
Okay, so you're going to need to tell me why you are not, because as the ranking member asked, there is a process, and thousands of companies have gone through it. And in my interpretation, it just means you don't want to be held accountable if anything happens, which the accredited agencies are going to be called to the carpet. Tell me why is the process skewed, flawed in a way that you haven't done it, because I've heard you say in your testimony that you plan on it. Now, how long has your company been active?
We've existed since late 2017.
17, okay. You may answer.
Yes. Under the current accreditation rules, we are obviously not allowed to charge a fee to assist with an initial claim. Our entire assistance model is focused on helping veterans with initial claims. When I look at a veteran, I'm looking at 3 pillars.
I heard you speak on the triad, which I think you're kind of skirting the line there a little bit, but go ahead.
Okay, well, aside from the triad, I want to look for things that a veteran should have claimed that they didn't. That's an initial claim.
Are you telling these veterans to collect this information for you, or are you actively doing it yourself?
The veterans have to provide the information to us, and then we help them develop it from there.
Just over the phone. You're not touching anything. You're telling them you got a guideline you're reading off of, like, hey, this is what you're going to do. I'm trying to find out why you're not wanting to become accredited.
We want to become accredited, but
Now you don't. You don't, sir.
Yes, sir.
Unless I'm absolutely missing something, because the organizations that are sitting to your left are. In 2017, as you said, tell me why.
Because under the current accreditation limitations, we cannot assist with initial claims, and that's where we believe the veterans need the most assistance. For us to most effectively help our veterans and look at them holistically, I need to be able to assist them across the entire process, both of what accredited agents are allowed to do.
So legislatively, there's a problem, apparently.
Yes, sir.
So that's something that you're asking us to fix.
Yes, sir.
And Ms. Robert, I would assume you would disagree with that statement. Or Mr. Murray?
Again, this is Congress's decision about initial claims.
Congress listens to the people. We are elected by the people. We're here to do the people's work.
Our members are accredited and help veterans typically after they've been denied, because as I talked about earlier, there's an appeals process. So veterans have a lot of choices to make when they get in a denial. That is typically when agents and attorneys have been involved in the process. A lot of our members do initial claims pro bono for free. So it's just a different way of representing veterans. But again, our members are accredited and are putting their names out there to say, we represent this veteran and we will be held accountable for it.
Mr. Chairman, the VFW's position is exactly that everybody can get accredited. If Ms. Robert and the other accredited agents and attorneys said, we want to talk about extending fees within the current system, we are here for that. But right now, people who are operating outside the system, refusing to get accredited, are saying you must change it before we start following the law. We do not agree with that.
Thank you, Mr. Murray. I apologize, I went over my time. Mr. Pappas, sir, we're going to move into closing remarks. Would you like to close out? Please do.
We're at closing. Well, I want to thank our panel and certainly all the veterans that are in the room here today for this important discussion. I see this problem as one of veterans being taken advantage of in our country, and us needing to insist on some basic guidelines here in Congress, yes, to protect veterans and ensure that they are able to seek the help that they need and successfully obtain the benefits that they all deserve. Now, I think there's some in this room that we've heard from that think the problem is their company is not able to make as much money as they possibly can on the backs of our veterans. And I just fundamentally believe that our veterans shouldn't be a profit center. There should be penalties for those who are violating the law and ripping off our veterans. And if companies believe that they're not violating the law today, then there's no reason why they shouldn't welcome some additional teeth in the law and some oversight by VA. So I think that the GUARD Act is pretty straightforward. And I also think that there was a lot said today about choice. We should be taking steps to bolster the choice that veterans have. We can do that by encouraging the hiring of more county veteran service officers, by supporting VFW and other organizations in the work that they do by strengthening the accreditation process to ensure that more can come into the system under that umbrella. And ultimately, and this came out today, working as hard as we can to strengthen VA's response times and their customer service for the end veteran to alleviate that frustrating process that so many endure. So I think that we've got an ability to work this through, and I hope that we will continue to engage the veteran community ultimately in the work ahead on this subcommittee. So I just thank you for the opportunity to hear these bills today. I think this was really instructive for us. I yield back.
Thank you, Mr. Pappas. You know, the VA, it's not a perfect machine. It's not. It's big, it's bold, it's beautiful at times, and it fails at times. And I don't mind wire brushing it and calling everything out. But the VA, it's ours. And I'm looking at the 100+ people sitting in the room with us today. It belongs to us. We dictate how it should be operated. Now, these two pieces of legislation are amazing. Yes, the veteran has every right to pick and choose exactly who moves their claims through. Colonel, Mr. Smith, 100%. They do. They have that choice. They earn that right. They put that uniform on, they can make those choices. Because yes, they do go to the VA, and the VA has failed multiple times. We hear it every day. It's no secret. We're trying to build out that infrastructure in order to handle us. And we are a very complicated group of individuals, especially the Marines. We will not let any organization take advantage of the most cherished asset we have in our country, which is those individuals on the dais and sitting behind you and amongst every other state in the country. And I hope I'm very clear on that. So as we talk about this legislation, full committee, what we will do, because we shouldn't be having this conversation. Now, if we messed up legislatively in the past, it's because we're listening to you. And we're listening to you right now. Now, it is our job on the subcommittee and the committee to fix this problem. Because what we want at the end of the day is for our veterans to be taken care of, their quality of life increased, so they can be happy until the day we have to lay them down. And I want you to know, yeah, if I'll get aggressive with you, because sometimes you deserve it. I can assure you I get my ass handed to me every day, because I'm voted in by the people. And that's who I'm speaking for, the 40,000 veterans in my counties, okay? I'd like to thank the ranking member again for this hearing and the other members of this committee. I ask unanimous consent that the statements for the record we have received today be entered into the hearing record. Hearing no objections, so ordered. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material. Hearing no objections, this meeting is adjourned.